Hi everyone, a very warm welcome to Thorough Newspaper Analysis. This is a combined video for Saturday and Monday, which is the 4th and the 6th of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. So first of all, we have the editorial segment, and here we have for discussion a very interesting article. So this is taken from Indian Express and it is titled as this: Should Shariat law apply to former Muslims in matters of succession? The question is now before the Supreme Court. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news, where today we have a couple of news items from the Supreme Court. I believe we have 4 or 5 updates from the Honorable Apex Court. So without further ado, let's start with the article. Let's first have a look at the title of it. Should Shariat law apply to former Muslims in matters of succession? The question before Supreme Court. Let's understand the context of it, and then we get into the legalities of the topic concerned. So the Supreme Court has recently said that it will examine the question of whether a former Muslim will be governed by Muslim personal law or by secular laws of the country when it comes to the matters of succession. So suppose there is a person who is no longer following the religion of Muslim and has renounced the practices and the religion of Muslim. So then will the person be governed by the personal law, or will the person be governed by the secular law when it comes to matters related to succession? When I say personal law, then I here mean the Shariat Act of 1937. Agreeing to consider the important point which was highlighted in this petition, the bench of Honorable the Chief Justice of India, D.Y. Chandrachud, and Honorable Justices J.B. Pardiwala and Manoj Mishra, they issued notice on a Kerala petition, Kerala-based petitioner's plea. Now let's understand what is the case before the Supreme Court and what is the factual scenario of this case. So see, the court was acting on the plea which was filed by the head of an organization which is an organization of former Muslims. So the head of this organization, the General Secretary, is Safiya PM. She is before the Supreme Court with this plea. The plea sought a declaration that persons who do not follow or do not want to be governed by Muslim personal law, they must be allowed to be governed by a secular law. Or to say the Indian Succession Act of 1925, both in matters of interstate and testamentary succession cases. Now, what does this term interstate and testamentary succession means? See, interstate usually means when, let's say, a person has died without creating interest in his property in favor of anybody. So post his death, we do not know how the property is to be devolved. There is no will, so to say. But when it comes to testamentary succession matters, there is a will which is directing you that, kindly give my property to so-and-so person. So an interest is created in another person's favor by the person who has died by virtue of that will that he has created. So a situation where the deceased has no will drawn up, it is called a situation of interstate succession. And whereas when the property it is distributed as per the deceased's will, then that becomes a matter of testamentary succession. In India, issues related to succession, they are governed by either the secular law or the personal law. So when I say secular law, what do I mean by that? By secular law, we mean the Indian Succession Act of 1925, and by personal laws, we mean the the Hindu Succession Act of 1956 and the Muslim Personal Law or the Sharia Act. In this particular case, the petitioner cited the Supreme Court's 2018 ruling in the case of Sabrimala entry temple matter, which highlighted the right to freedom of religion, which is guaranteed under Article 25 of the Indian Constitution. The petitioner here argued that freedoms which are guaranteed under Article 25 of the Indian Constitution, it also must include the right to not believe in religion. She added that someone who leaves their faith, their religion, shouldn't have to face any disability or any disqualification in matters of inheritance or other important civil rights. Her father hadn't officially left his religion, but he was a non-believer, which resulted in the peculiar problem for her in inheritance matters. This was the core of her matter or plea before the Supreme Court. Now let's try to understand how generally matters of inheritance are governed when it comes to Muslims. So inheritance for Muslims in India, it is governed by the Muslim Personal Law Shariat Application Act of 1937. This act, it's a very small act. It codifies the Shariat or the law governing Muslims, and it is made up of Quranic principles, teachings, the hadiths, or the practices of Prophet Muhammad. According to this act, there are 12 categories of legal heirs which are identified, or to say sharers, who get a share in inheritance. And these include your spouse, that is to say your husband, your wife, then your children. So that is to say your daughter, then son's daughter or son's sons, and so on. And then comes the next level, which is that your parents. So father, paternal grandfather, and others. Now, apart from these 12 categories of sharers, there's another category of sharer that is called usually referred to as the residuaries. They include the aunts, the uncles, the nieces, nephews, and other distant relatives. The value of their shares, it depends upon several situations. Now, for example, a wife takes 1/8 share of her husband's property upon the husband's death if they have lineal descendants like their children. If they do not have lineal descendants, do not have children, then she takes 1/4 the share. Moreover, a Muslim's estate can only pass to a Muslim which prejudices, that is to say, it adversely affects the wife or children who are following another religion. Another important rule is that daughters, they cannot inherit more than half of what their brothers inherit. So let's say the brother is inheriting X amount of the share in the property, then the daughter or the sister will have to inherit half of that. So the rationale, which is given often here, is that under the Muslim law, a female shall receive mahr and maintenance from her husband upon marriage, while males, they solely have their ancestors' property for inheritance. Further, it is also cited as a reason that these laws they emanate from custom, which said that the males were responsible for maintaining their wives and children, and therefore they should be entitled to more share. Under Shariat, only 1/3 of the estate can be willed in favor of anyone, and the remainder will have to be divided as per the complex religious law. Therefore, a Muslim couple has no way to make someone their sole heir. In the present case, the advocate representing Safiya, the petitioner here, told the courts that these provisions would adversely affect the rights of the petitioner. Notably, many Muslims, they choose to register their marriages under a secular marriage law, which is what? The Special Marriage Act of 1954. This was the act which was at the core of the matter with respect to same-sex marriage. So this is not based on religion. This is a secular law. So this is done to avail the option of being governed by a secular inheritance law like the 1925 Indian Succession Act, the act that we saw here. Now let's see provisions related to this case. So in her petition, the petitioner approached the court seeking a declaration to not be governed by Shariat for matters under sections 2 and 3 of the 1937 Act. Now, for understanding this para, we have to understand what is section 2 and what is section 3 of this act. 3 we'll understand later, but for now, let's have a look at section 2. So section 2 deals with the application of personal laws. It says that in certain areas, one of the area identified is interstate succession and special property of females. So in certain areas which are listed out, the rules of decision in cases where the parties are Muslim shall be the Muslim personal law or Sharia. essentially means, this was also highlighted in the case of Sharia Banu versus Union of India. This is 2017 landmark judgment of Supreme Court, which struck down the practice of triple talaq as unconstitutional. Here, the court reaffirmed that Section 2 mandates Muslim personal law would be exclusively adopted as the rule of decision in matters which are listed under Section 2. So let's say there is an X matter and it is listed out in Section 2. So with respect to that matter which is listed out in Section 2, here Muslim personal law, Shariat, it would be exclusively adopted as the rule of decision. And here one of the matter listed out is interstate succession and special properties of female. Now let's talk about Section 3. So Section 3 talks about the fact that anyone who satisfies the three conditions, they can have Section 2 applied to them and his descendant. So what does this essentially mean? So Section 3, essentially, it is allowing a person to make a declaration for wanting to be governed by Sharia law. So from these two sections, what we can see is there is an option for parties who are able to fulfill these three conditions to get the Sharia law applied to themselves. But so far, we've not seen any provision which is saying that you can, renounce with Sharia law and then get applicable upon you the secular law of succession. That is the 1925 Act. We've so far not seen any such provision, right? So let's talk about what are the conditions in Section 3. It is that if the person is Muslim, the person is competent to contract under the Indian Contract Act. So all the the requisites with respect to competency which are identified under the Indian Contract Act, if you are fulfilling those, and then you should be a resident of the territories where the Act applies. So if you have these three prerequisites, then you can have Section 2 applied on you. Now let's talk about what about the application of Shariat for people who renounce their faith. So at present, Muslims who wish to renounce their faith, they are also bound by Sharia law, unless they formally declare that they wish to opt out under the 1937 Act. So if, let's say, you've renounced your practice and you've said expressly and followed the process under 1937 Act of renouncing your faith and you no longer want to continue, then you can do so. But if you do not renounce formally, then you'll be governed and bound by Sharia law. But doing so, it would render them without a law to govern aspects of inheritance and succession. Why? Because there is a section in the Indian Succession Act, the secular law, which specifically excludes Muslim law from its purview. And that section is Section 58. However, there is one exception to it. The exception exists in testamentary succession. So in cases where the subject matter of property is an immovable property, which is situated in states of West Bengal, Chennai, and Bombay, Muslims are bound by the 1925 Act. Now let's talk about what has the court said in this matter so far. So while this was said initially by the CJI, so while the CJI initially said that Muslims in India, they are governed by Sharia, irrespective of whether to choose to believe in their religion or not, the bench, however, later eventually decided that they're going to hear this plea further. The CJI stated that as per Section 3 of the Shariat Act, one has to make a specific declaration to be governed by the Shariat. Simply put, the court so far has said that although one can declare that I am not going to be governed by the Shariat law, the Indian Succession Act creates a vacuum for such people who choose to leave their faith, but they are left without any secular law to govern matters or aspects of inheritance. Taking note of the fact that there is no secular law on wills and legacies for Muslims, the court sought response from the centre and Kerala governments while directing the Attorney General of India to appoint any person as law officer to assist the court in this matter, and the case is now will be taken up for further hearing in July. So it is going to be an interesting matter, and we certainly will be recording and reporting on this matter further. Now with this, let's proceed with the national news category, and this is the first update here. India to host delegation from Kenya And the matter of or agenda of discussion is going to be the outsourcing of Cheetah. India is likely to host a delegation of Kenyan officials later this month to explore the possibility of sourcing cheetahs from East African country for the next phase of Project Tiger. As part of Project Tiger, India plans to introduce 8 to 14 cheetahs annually for 5 years, subject to the availability. The Gandhi Sagar Wildlife Sanctuary, which is located in Madhya Pradesh, it was chosen as the second site for reintroduction of cheetahs last year. This is an important update. You will mark these information pointers like this wildlife sanctuary, then what is Project Cheetah, how many cheetahs are annually to be, relocated or translocated. Next up is an update in the category of science or in the category of evolution of Earth and all of those matters. So oldest evidence of Earth's magnetic field, it is found in rocks. Geologists from MIT and Oxford University, they've discovered the oldest evidence of Earth's magnetic field in 3.7 billion year old rocks from Greenland's Isua supracrustal belt. So what is a magnetic field? What does it do? What's its utility? See, the Earth's magnetic field, or the magnetic field of any planet for that matter, it plays a crucial role in protecting the planet from harmful solar radiation and cosmic rays. It helps sustain a stable atmosphere, allows the presence of liquid water, and which is essential for life. So for understanding the history and strength of Earth's magnetic field, it provides insights into the Earth's evolution and its potential to support life. So for the purpose of exam, what you may note is the location of where this discovery has been made. Worldline ePayments India received RBI approval as payment aggregator. Worldline ePayments India, it has announced its receipt of approval from Reserve Bank of India to operate as a payment aggregator. Micron's venture in India, Rollout first India-made chips. Micron India's Sanad unit, it gears up to unveil its inaugural batch of domestically manufactured semiconductor chip in 2025 with a focus on global exportation. These are two very, very important updates. Please mark a star or make notes of this. Vaishali Ramesh Babu achieves FIDE Grandmaster title. The chess prodigy R. Vaishali, she has officially bagged the title of 84th Grandmaster. She has also become the 42nd woman to reach this rank, and certainly her ascent to this rank, it is going to inspire a lot of chess enthusiasts, and she's certainly made all of us proud. Maushumi Chakravarty appointed as the DG, the Director General of Akashvani News. Senior Indian Information Service Officer Maushumi Chakravarty has assumed the charge of the DG of Akashvani News. Another important update in the category of important days for today. This is with respect to World Press Freedom Day. Please mark the date. It is 3rd of May. United Nations General Assembly, the UNGA, it declared May 3 to be the World Press Freedom or just the World Press Freedom Day. Press Day or the World Press Freedom Day, both are the same. It is observed, commemorated, marked on 3rd of May. Now let's talk about the historical essence of it and why it is observed. So it is observed to raise awareness of the importance of freedom of press and remind governments of their duties to respect and uphold the right to freedom of expression. Let's talk about some of the key legal provisions, and you may cite it in your essays also, where let's say, if you talk about freedom of press. So there is Article 19 of the UDHR. UDHR is the Universal Declaration of Human Rights of 1948. Article 19 of it, it pertains to press freedom or freedom of speech. So it marks the anniversary of the Windhoek Declaration. This is a statement of free press principles which was put together by African newspaper journalists in Windhoek and this was in 1991. As far as the theme for 2024 is concerned, it is a press for the planet, journalism in the face of environmental crisis. So there is a focus on the climate change, environmental crisis, and the press freedom. 8 railway stations in Amethi, UP, it has been renamed. The Union Ministry of Home Affairs has granted approval. The approval has now come forth. So has granted approval to UP government to rename 8 railway stations in Amethi district. And the purpose of that is to preserve the cultural identity and the heritage of the region by honoring the local temples, saints, idols, freedom fighters through the new names of these stations. Now, the proposed renaming is with respect to these 8 stations. First is we have Kasimpur Halt. This will be renamed as Jesh City. Then for Jesh, it will be renamed as Guru Gorakhnath Dham. Bani will be renamed as Swami Paramhans. Then we have Misroli. It is going to be renamed as Ma Kalikan Dham. Neelgad is going to be renamed as Maharaja Bijli Pasi. Then we have Akbarganj. It is going to be renamed as Ma Ahorwa Bhavani Dham. Then Wasirganj is going to be renamed as Amar Shahid Bhale Sultan. And Fursatganj is going to be renamed as Tapeshwar Nath Dham. So you may make a list of all of these railway stations and their renames. India and Indonesia resolved to expand defense ties. India and Indonesia, they've moved these 2 countries, they've vowed together to expand overall bilateral defense ties, especially in areas of maritime security and industrial engagement for production of military equipments, defense equipments. Now, where did this collaboration or this promise of collaboration happen? So this happened between the 2 countries at the 7th India-Indonesia Joint Defense Cooperation Committee meeting. This was held in New Delhi. This is also important update. National Women's Hockey League 2024, it commenced in Ranchi. The National Women's Hockey League 2024 began at the Maran Gomke Jaipal Singh Mundra Astro Turf Stadium in Ranchi. You may make a note of the venue of this tournament. It is scheduled till May 9th among 8 participating teams. This is also another important update. CAG Murmu and Nepal's Auditor General, they've signed an MOU for auditing collaboration. The Comptroller and Auditor General of India, CAG, he is Girish Chandra Murmu. He has signed an MOU, a Memorandum of Understanding, with Toyam Raya, he is the Auditor General of Nepal, to enhance cooperation between the 2 institutions. This MOU, it seeks collaboration between the 2 supreme audit institutions and the exchange of expertise in the field of auditing. This is a very interesting update, and with this, we've come to the international segment. This is an interesting update in the world of AI. Ukraine's Ministry of Foreign Affairs has introduced an AI-generated avatar as its digital spokesperson. And this is the first of its kind in the world of diplomacy. So far, we've seen AI anchors or use of AI in so many fields. Now, AI has ventured or made its way in the world of diplomacy as well. Victoria Shi, the AI diplomat, has been created to save time and resources for Ukrainian diplomats. The AI spokeswoman has been created to deliver prepared. So she has been already prepared and fed with data. So she is going to be delivering prepared official statements on behalf of the ministry. And this is done using visual avatar generated by AI. And the AI's diplomats' tone and voice, they are modeled on Rosalie Nombre, a Ukrainian singer and TV celebrity. So the voice modulation, the voice tone is taken from the celebrity concerned here. This is also another important update. If you remember, a couple of days back, we did a TNA article on how ISRO has made a certain observation on the outer space pollution, because there are, a lot of objects, satellites, and other objects which are placed in the orbit. So therefore, there is now something called the concept of outer space pollution. So this is more or so, an interesting update in that domain itself. US space scientists rediscover satellite missing for 25 long years. After 25 years, US Space Force rediscovered, raising questions about space junk tracking and management system. So the US Space Force has located a tiny experimental satellite which went missing in orbit for a staggering 25 long years. The satellite was named as S737 Infrared Calibration Balloon. It was launched in 1974 alongside a massive Cold War era spy satellite. This is another important update. US President has conferred the highest civilian award in US on 19 persons. So let's talk about some of the names. US President Joe Biden will extend the highest US civilian award to 19 people. Some of these have been listed here. If you want, we can provide you a comprehensive list of all these 19 persons as well. So first we have the Team USA swimmer Katie Ledecky. Then we have assassinated civil rights leader Medgar Evers and television host Phil Donahue. Apart from that, we have another name. You must have heard of a name last year or this year when the Academy Awards were given out. So the honoraries list, it play a special homage to the first in their fields. So first in their fields, we have the actress of Everything Everywhere All at Once. She won the first Asian, she's the first Asian to win the Academy Award for Best Actress. She created history in the past and now she's won the US highest civilian award. Her name is Michelle Yu. Next up, we have Ellen Ochoa. She's the first Hispanic woman in space. Another one is Tim Thorpe, the versatile athlete who became the first Native American to win an Olympic gold medal in 1912. Next up is an update in archaeology. So archaeologists discover a prehistoric settlement in Serbia. A prehistoric settlement of massive size. It has been discovered in the Banat region of northeastern Serbia. Archaeologists date back to the previously known settlement. They date back the previously known settlement to some 7,000 years ago, which is much later than the late Neolithic period. This settlement, it is located near the Tamis River in Banat region of northeastern Serbia. It's a landlocked country in the Balkans. Next up is an update in the sports category. West Indies cricketer Devon Thomas. Devon Thomas is being banned for 5 years for match fixing. He's banned for 5 years with 18 months suspension after admitting to 7 charges, including those related to match fixing. The sentence will be backdated to May 23 last year, and he'll be eligible to play again in November 2026. Purnima Devi Burman has received Green Oscar Whitley Gold Award 2024, and this is for her exemplary conservation efforts, which is aimed at preserving and protecting an endangered bird species. It is the greater adjutant stork. This is a bird which has a tall figure like an ostrich, so to say, and its beak is very long. So that's a bird, and the exemplary efforts that she made to preserve these endangered species and its wetland habitat has gotten her this award. She hails from Assam. She's a biologist. Her name is Dr. Purnima Devi Burman. The award that has been conferred upon her is Whitley Gold Award 2024 Green Oscar. You may mark a star here. This is also another important update. And this has brought us to the legal category for today with the first update coming from the Honorable Supreme Court. Bank vicariously liable for conduct of its employees, the Supreme Court has held. The Supreme Court has recently held that recipients of a fixed deposit, they cannot suffer at the cost of criminal conduct of the bank officials, and that In such an event, the bank would be held vicariously liable for the conduct of its employees. Here in this case, the Supreme Court bench was hearing an appeal against an order of the National Consumer Dispute Redressal Forum, which observed, and the bench observed that the impugned order overlooked crucial findings of the district forum. The court observed that the findings of the National Forum are contrary to record and cannot be sustained. The bank is vicariously liable for acts of its employees. The name of this matter is Leelavati Devi and another versus District Cooperative Bank Limited. Another update from Supreme Court. This is in the matters of service law. Supreme Court has recently observed that, let's say there is a meritorious candidate from reserved category. However, the candidate did not avail the reservation benefit which is available or relaxation, then such reserved category candidate would be treated at par with unreserved or general category candidate on the strength of their marks. The name of this matter is Dipendra Yadav and others versus State of Madhya Pradesh and others. Next up is an update in the category of Juvenile Justice Act. The Supreme Court has observed that the plea of juvenility of the accused may be raised before any court at any stage, even after final disposal of the case. So the court held that such a plea of juvenility cannot be rejected without conducting a proper inquiry. Noting that the Juvenile Justice Care and Protection Act, which is the law for governing of juveniles, it provides a comprehensive mechanism to consider the prayer of juvenility of an accused claiming to be a child on the date of commission of the offense. The judgment authored by Justice Sandeep Mehta observed that proviso to Section 9, subsection 2 of the JJ Act clearly enumerates that plea of juvenility may be raised before any court and it shall be recognized at any stage, even after final disposal of the case. The High Court, however, in present case, did not consider and decide the prayer of juvenility raised on behalf of the appellant, and therefore that was held by the court to be not the right approach. The name of this case is Rahul Kumar Yadav versus State of Bihar. Misuse of Section 498 IPC. Supreme Court requests Parliament to amend corresponding section in Bharatiya Nyaya Sanhita, raising serious concerns about the misuse of the section of IPC which provides for cruelty by husband and relatives of the husband, which is Section 498A of the IPC, proceedings against the husband and in-laws by the wife. The Supreme Court requested the Parliament to bring out necessary changes to the new IPC, which is the Bharatiya Nyaya Sanhita 2023, which contained provisions such as sections 85, 86, which is akin to Section 498A IPC. The Supreme Court said in this matter, we request the legislature to look into the issue as highlighted above, taking into consideration the pragmatic realities and consider making necessary changes in sections 85 and 86 respectively of the BNS before both the new provisions come into force. The court further noted that the text of the new provisions of the BNS is nothing but a verbatim, that is to say, same-to-same reproduction of 498A of the IPC, except with the difference that the explanation to 498 IPC is now by way of a separate provision, which is 86. Also, in the case of Preeti Gupta versus State of Jharkhand, which is 2010 case, Supreme Court had flagged concern about the reflection of exaggerated versions of incidents in Section 498A complaints and invited attention of the legislatures, the lawmaker, to bring changes to the provisions while taking into consideration the pragmatic realities and public opinion. The name of this matter is Achin Gupta versus State of Haryana and another. If you remember, recently the Supreme Court imposed fine to the tune of rupees 5 lakh upon the father of a woman who misused her position to file these sort of complaint in different positions to harass the husband. So with this, we come to an end to the TNA. Thank you so much for being with us.